actions to try to address the problem, and what my presentation is going to try to cover today is a legal analysis of how the courts are reviewing those actions and adjudicating them, because not all of the actions the courts have taken the schools have taken or governments have taken to address anti-Semitism have withheld constitutional scrutiny. So I'm Joe Cohn. I'm the executive director of the Center for Academic Freedom and Free Speech. We've existed now for a little under a year, and I've been at the center for just a few months now. It's my first foray into academia, having spent the majority of my career, 20 years roughly, doing free speech work broadly for nonprofits like the ACLU, and over a dozen years as the head of government relations for FIRE, as you heard about if you were in this room for the last panel, which is in America the premier, I would say, First Amendment organization now, and has had a long history of specific emphasis on free speech and academic freedom on college campuses, and I also did policy work at Hadara Academy before coming to Yale. So that's my background. In that work, I had drafted and worked on significant pieces of language of nearly every campus free speech piece of legislation that has been enacted in the United States. So I'm going to turn into some substance and stop talking about me. I'm going to start with a little bit of a legal primer for the audience, because I know you're not all legally trained in the United States. Most institutions of higher education are obligated by federal anti-discrimination law to combat discrimination and harassment on the basis of a variety of protected classes. Under Title VI, that includes perceived race, color, national origin. None of the federal anti-discrimination laws applying in the context of education deal specifically with religion except in the context of admissions. And that's Title IV. But since 2004, there's been an ongoing, I'm going to use the word policy, but what I mean by policy is practice of considering anti-Semitism and Islamophobia as being covered under Title VI when it's on the basis of stereotypes about shared ethnic characteristics. So that wouldn't be when the anti-Semitic activity is because of a religious disagreement, for example. And that policy was announced in what's called a Dear Colleague letter, which is informal guidance that isn't binding, that says this is how the government is perceiving this issue and how we plan on enforcing it in 2004. And so that's George W. Bush administration, and it was continued until present day. Another short primer. All public institutions of higher education are obligated to comply with the First Amendment. So freedom of expression protections. And most private institutions, and this is not a uniform rule across the country in every court, but in different jurisdictions, the majority of the courts that have looked at this question have said private institutions have to respect any promises and commitments they made to provide any rights. And that would be free speech rights, that would be academic freedom rights, that would be due process rights, but only if they promise it. So if you say as a private institution, we don't care about those values, you're entitled to make that decision as well, but they're viewing it in terms of contract law and then importing in First Amendment law to decide. If you're one of those institutions that are going to provide academic freedom, of which roughly all but 10 or 12 in the country have said so, then that's what we're going to look to. So for the rest of the presentation, I'm just going to not make that distinction of public and private. So we're talking about a majority of the schools. Last legal primer. The First Amendment is pretty broad. It's the strongest free speech protections you see anywhere in the world. And the exceptions to freedom of expression in the United States are narrow, and some of them will be applicable today. True threats, as separate from hyperbolic speech, are not protected. Incitement to imminent acts of lawlessness, imminency, is really crucial here. also not protected. Harassment, with the very specific defined definition that the political parties fight over, some aspects of the definition, but the Supreme Court has set one. Separately from the employment context, they set a separate one for education to give people more leeway to be combative in education, under the theory that you learn better when you can speak more freely, as opposed to employees that should be, not rocking the boat so that they're smooth operations. Okay, so those are the main exceptions. But the main kind of thread with all those exceptions is they're not about the viewpoints expressed. The exceptions are really about trying to get at what makes the verbal activity more akin to expressive conduct than really just talking about views. So it's not about how offensive it is. There is no hate speech exception to the First Amendment. There is no hate speech exception to the First Amendment. You can say hateful things, but you cannot engage in discrimination. Okay. So those are the legal primers. So now I'm going to talk about what the government has done to address anti-Semitism. And I'm going to take you through 3 administrations to kind of see how it's shaped up. Trump administration 1, what do? It issues an executive order. 2 main legal components of that first executive order during the first Trump administration. Component number 1, it says it was proper for the Department of Education to make that guidance document earlier that talked about shared ethnicity being covered under Title VI. So this is the first time that a legally binding document, an executive order, now says that that's the right interpretation. Okay? So that's thing 1. I don't think that's particularly controversial in the civil liberties community. Thing 2 is far more controversial, and that's that it adopted the IHRA definition of anti-Semitism and instructed federal agencies that enforce Title VI to use that definition when determining whether or not there's a violation. The IHRA definition. The IHRA definition is controversial in this particular application for a variety of reasons that I'm going to explore really briefly, because I'm sure there will be other presentations that do more depth here. Start with what the definition says. The IHRA definition defines anti-Semitism as, I'm quoting here for a moment, a certain perception of Jews which may be expressed as hatred towards Jews. Rhetorical and physical manifestations of anti-Semitism are directed towards Jewish or non-Jewish individuals and or their property, towards Jewish community institutions and religious facilities. So one thing that you might just inherently pick up is the inherent vagueness of what does it mean to have a certain perception of Jews. If we were to poll this entire audience, or maybe those of you who are watching later on YouTube were to poll yourselves about what a certain perception of Jews means, you might get a lot of different answers that are inconsistent with each other. The thing about vagueness as a doctrine is that you can't punish speech if it's unclear what people can or cannot do. Okay, so that's why vagueness isn't a problem if you're using that term for how you collect data to get a rough approximation of what's happening across the globe, what's happening in the United States, what's happening on college campuses. If you're using it for data collection, vagueness isn't an issue. You might want to try to be as precise as possible to get more accurate data if that's your goal. But if you're trying to get a snapshot, that's not necessarily a problem. But when you're talking about how do we punish people for what they have done and or said, vagueness now comes into a direct clash with the constitutional prohibition of vagueness. Another problem with the definition is it incorporated a list of contemporary examples, and I'll just talk about 2 of them. One of them is drawing comparisons of contemporary Israeli policy to that of Nazis, and the other is applying double standards by requiring of Israel behavior not expected or demanded of any democratic nation. I want to make 2 observations about this. One is, each of those things may very well be anti-Semitic in individual contexts. But there's no doubt under the case law that I just discussed and the exceptions that I mentioned to you, that they're both protected. There is no country in the world that you're not allowed to say, this policy that you were engaged in might be similar to Nazi policies. Now that argument might be right or might be wrong, but the First Amendment doesn't decide, and I would argue to you no country's free speech laws should decide on the basis of whether or not you are right or wrong what your speech rights are. You can say American immigration policy is Nazi-esque. You can say that Germany's taking a turn back to Nazi times, and you can say that make these allegations against Israel as well. as unpersuasive as that might be. Applying double standards is similarly true. There is no "you can't be a hypocrite" exception to the First Amendment. Hypocrisy is protected because on a long enough timeline, almost all of us will sometimes be hypocrites. I am only 46 years old and I'm still waiting for that instance in my life, but at some point I suspect that might happen. But the EO has not been challenged in court, so it's still good law right now. There have been a few cases that have challenged the constitutionality, however, of applying the definition to college disciplinary proceedings. One was Students for Justice in Palestine, a student organization, versus Abbott, who's the governor of Texas. And in that decision, that federal court noted the constitutional problem with using the definition to punish students for speech. There's been another case where Jewish organizations were talking about chilling effect on them, and they cited the IHRA definition of, hey, all of these things violate the IHRA definition, and the court says in what's dicta, so not controlling, holding, not binding, it commented a couple months ago that there are significant constitutional problems with using it to punish it, as the Israeli or pro-Israeli and Jewish student organizations are asking that court to do. When they're saying just take judicial notice that these things that we're complaining about are causing this chilling effect with violating the IHRA definition. So fast forward to the Biden administration. Biden administration does a comprehensive plan on addressing anti-Semitism in all contexts: sports, entertainment, education, business, employment, all of it. There are a number of serious First Amendment concerns with some of the other contexts, but I'm only going to limit what I'm talking about here to the educational context, where the two things to note are they de-emphasize the use of the IHRA definition, so they no longer are saying you must use it in your enforcement of rules on campus, but they replace the harassment definition on campus with a lower threshold of what it means to count as harassing speech across the board, not just, they're talking about it in the context of harassment, but politicians from the left have been trying to lower that threshold in the context of sexual harassment for about 15 years. We talked a little bit about that in the earlier panel in this room before. So this is a continuation of that effort. It's a little bit less speech protected. So now Trump 2, and this is where I'm going to spend the bulk of my time. I'm going to try to be fast and mindful of the time that we have. A quick note before we jump into Trump 2's actual policy stuff, to talk a little bit about context. During the campaign, I'll call it a re-election campaign, even though there was an intervening administration, now Vice President Vance, then Senator Vance, spoke at a conference, and it was entirely about his views on higher education. That was the topic of this speech, and it was titled "The Universities Are Our Enemies." That was his actual title of his speech. And he said, and I'm going to quote here for a moment, he said, "I think if any of us want to do things that we want to do for our country and for the people who live in it, we have to honestly and aggressively attack universities in this country." So that's the direct quote. I'm not paraphrasing. So that's kind of the framework of the general hostility, which comes not just in terms of this issue of addressing anti-Semitism, but in terms of how to address diversity issues, in terms of the view that universities are enclaves of left-leaning political power, and how to gain advantage there. So that's the context. And now I'm going to talk about a few of the things that the Trump administration has done to at least partially be motivated by the desire to combat anti-Semitism, but there's at least with that quote good reason to believe that they have mixed motives or additional motives as well at the same time. And I'm not going to go into the debate of what's the percentage of their motivations or how sincere, but I just wanted you to understand that that's the context here. So the first thing that they do is they issue a new EO on the day of being sworn in for the second term, and the new executive order on anti-Semitism tells the Department of Homeland Security to make sure that institutions of higher education are familiar with their obligations to not allow people to be admitted as visiting students or professors if they are involved in any terrorist activity. And I'm paraphrasing that phrase, involved in terrorist activity, because they just talk about, they say their obligations to, as terrorism as a justification for inadmissibility. And Roy, is that my 5-minute mark? Okay, thank you. So, I'm going to speak a little bit faster than I ordinarily would, because I really want to get into the meat here. So that's the first thing that they do. Then, in March, you have the arrest of Mahmoud Khalil, who is a recent graduate of Columbia University, pro-Palestinian activist, legal permanent resident, and they begin removal proceedings against him. Several others, Tufts graduate student Osirk, who wrote an op-ed supporting the Palestinian position. She's picked up and arrested by immigration enforcement on the streets in a video that's going viral. And you have Secretary of State Rubio saying, if you apply for a visa to enter the United States and be a student, and you tell us that the reason you're coming to the United States is not just because you want to write op-eds, but because you want to participate in movements that are involved in doing things like vandalizing universities, harassing students, taking over buildings, creating a ruckus, we're not going to give you a visa. So you list a number of things. Now, is there a creating a ruckus exception to the First Amendment? No. Is there a writing an op-ed exception to the First Amendment? No. Is vandalism unprotected? Yes. Okay, but when you're mixing all things together and you're not separate, participating in a movement, does that mean agreeing with the movement? Does that mean that you now own the sins of everyone else who is involved in your movement? So that's one of the key issues in the case. So there are two cases, an Osirk case over that situation. It's pending. She's been released on bail, and the court has decided that her free speech claims and due process claims could proceed. Then there's another case, AAUP versus Rubio. AAUP is a long-standing academic freedom organization in the United States, and they are raising the issues of Khalil and others, arrests and detentions and removals, and making an argument that it is chilling the speech on campus of others, the students and the faculty there. So they're not representing Khalil, they're not representing these people, they're representing the others on campus whose speech might be chilled. And the court says, and this is my longest bit of reading of excerpts, because I think it's really important to hear what the court did. It's a really long opinion here. It said, this case, perhaps the most important ever to fall within the jurisdiction of this district, or ever, this is a judge who's been a judge since the Reagan years, squarely presents the issue whether non-citizens lawfully present in the United States actually have the same free speech rights as the rest of us. The court answers this constitutional question unequivocally, yes they do. No law means no law, and that's a quote of the First Amendment. Congress shall pass no law abridging the freedom of expression. Okay. The First Amendment does not draw President Trump's invidious distinction, and it is not to be found in our history or jurisprudence. No one's freedom of speech is unlimited, of course, but these limits are the same for both citizens and non-citizens. And then they talk about how the evidence of Secretary Rubio and other secretaries in their statements make it perfectly clear that it was about the speech, it's about the op-eds, etc. Federal funding freezes, I'll get really fast. Universities in the United States depend on federal funding with a large extent of their funding. MIT, for example, in the 2023 year, had $1.6 billion in federal funding, and that was 48% of its funding. So what did they do? In February 28th, the Trump administration task force to combat antisemitism announced that it was investigating 10 institutions of higher education. Then they sent demand letters to schools. One of them is Harvard. They demanded Harvard initiate an independent investigation into academic departments that, according to the government, quote, most fuel anti-Semitic harassment or reflect ideological capture. So ideological capture is different. That's the argument that you're just lefties. That's not even tied to anti-Semitism. It could be in that instance also be classes dealing with this issue, but they're just making a broader statement about intellectual capture, and make reforms to its student disciplinary process to ensure that the policies are sufficient to prevent disruptions to scholarship, classroom learning, teaching, or other aspects of normal campus life. Okay, so what's happened? Oh, they also demand that Harvard stop funding student organizations that support the pro-Palestinian cause. So, the feds freeze $9 billion of funding to Harvard after Harvard says we're rejecting these demands on academic freedom grounds. They revoke Harvard's ability to enroll any international students. These are two separate actions that they take. And then in comments by the president, he says, well, maybe we should also revoke its nonprofit status, which would make it so you can't donate to Harvard, untax deductible, a lot of implications of that. Harvard sues in 2 lawsuits, one dealing with the inability to enroll international students, and the other one dealing with the funding freeze, and they've prevailed in getting preliminary injunctions on the international students and its enrollment, and that was later turned into a permanent injunction. And then they've also gotten a preliminary injunction based on the enrollment of foreign students. So that's my description of what has happened. I hope in the Q&A we will get an opportunity to discuss my last page of notes. I'm so close to making it in time. My last page about what I think the government should be doing instead that would also support efforts to combat the very real problem of anti-Semitism without clashing against First Amendment norms. With that, I really thank you, and I look forward to the robust conversation I hope we'll have the rest of the day, both in this session and throughout. Thank you so much, Roy.
I promise to ask you that question.
Okay, thank you.
So our next speaker is Andy Lester. Andy really has a 360 view on these issues because he practices law at Spencer Fane LLP, one of the largest U.S. firms in the U.S. He was a judge in the Western District of Oklahoma and a regent of the Oklahoma University system.
Correct.
So he's seen these issues from all their angles.
Advance these things, I just. Okay. Well, it's great to be here. I'm the non-academic in the group. I know, at least let me put it this way, I'm the one that doesn't spend full time on higher education. But I have spent a lot of my time dealing with higher education, as you heard, as a regent of the state system of higher education in Oklahoma. We have 25 institutions of public higher education. And what we have done to deal with a lot of these free speech issues, instead of taking a piecemeal approach or instead of simply adopting some statement promoting free speech rights, we've done something different. We have legislation, and I do have to apologize for my colleague who was planning to be here by Zoom, but unfortunately cannot be because of an emergency situation she had a few hours ago, which was unfortunately resolved. We call it the Oklahoma experiment because we have legislation. Joe was actually instrumental in helping draft the legislation. Excuse me, I'll call it House Bill 3543. It creates and empowers something called the Oklahoma Free Speech Committee. I happen to be the first and thus far only chair of that committee, and my colleague, Ms. Pitts, chairs one of our task forces. It was brought to life in November of 2022. It's an advisory arm of the Oklahoma State Regents for Higher Education. Let's see if I can actually move this thing forward properly. Look at that. And it does several things, and you can see what these several things are. It reviews the free speech policies of Oklahoma's public universities. It reviews university training on free speech for improvements, and it makes recommendations to the universities on improvements to free speech policies and training. It's also responsible for reviewing free speech complaints. Anybody can file a free speech complaint. Believe it or not, in 3 years of existence, well, for most of that time we had only one complaint. It really wasn't a free speech complaint, and that's what the finding was. But starting in October of this past year, 2 in October, 1 in November, we got 3 additional complaints. They are not resolved yet. We're certainly looking into them. But we have, that's one of the jobs. And finally, what this committee does is it educates, and I think this may be one of the most important things, campus administrators about individual free speech rights. So, let me contrast the one state that does something somewhat similar. Iowa does something somewhat similar. It has a free speech committee, but it wasn't created by legislation. It was created by the regents of the Iowa regents. They only govern 3 of their schools. Now, it's the 3 major universities that are in Iowa, but they do not govern their 2-year schools, for example. It's set up by the Board of Regents. Ultimately, that means the Board of Regents can dissolve it. They haven't dissolved it. They did combine it with their Student Affairs Committee, which I think lessens its import. But that's the one state that comes close to what we do in Oklahoma. So, what does it mean for the future of higher education? Well, in April of 2022, when the state legislature adopted and approved, and the governor signed into law HB 3543, that empowered the regents to do a couple of things. The first was to set up what the committee would look like. This law established the committee, but it didn't say how many members or anything like that. So what the state regents did was first to create a committee, and it was a 9-person committee, just like the state regents are a 9-person board. And then what the state regents did right before the law went into effect in November, they adopted the Chicago Principles. Now, when I say they adopted the Chicago Principles, it was really pretty simple. The Chicago Principles were drafted, for those of you who don't know, for the University of Chicago, which is a private institution of higher education, and they deal with free speech on campus types of issues, and they're very pro-free speech. What the state regents adopted was a revised version. Let's see, I took that slide, not quite to that slide next, but I'm going to go through there. These are a couple of the revisions. They're at the beginning and at the end, and I don't want you to focus so much on what they say. What I will, these are the 2 major revisions, and all these major revisions do, it takes this sentence right here, moves it up to that paragraph, which was actually several paragraphs earlier, but then it does what essentially you would see in this last part. It basically makes the Chicago Principles, which are applicable to one school, and it's a private school, and as you heard Joe say, the First Amendment does not apply to private schools, at least not directly, but it means, it takes them and makes them applicable to an entire public system of higher education. So, it's essentially the same document, and I want to tell you sort of an interesting political story that I think explains a lot about how reality actually works. I actually drafted the document, the Chicago Principles, years earlier, the Oklahoma version of the Chicago Principles, and I was a member of the state regents at the time, and I was able to get a 2nd out of 9, but I couldn't get any votes on the thing. I just couldn't get it done. It was very frustrating to me. This is back in 2016 and 17. And I wanted to get it done, and I had a 9-year term. I was planning on waiting for a few years. I'd get more members who agreed with me. I wasn't too concerned about that, and we'd get it done, but then I stepped off of the regents for a variety of reasons. And then, here in 2022, it was not controversial. I mean, I had people that were telling me, though, they'd never vote for this, and they voted for it. And they didn't even, it wasn't a controversy at all. And it just goes to show sometimes that timing is really, really important. So, what does this committee do? Well, it's been divided into 3 task forces, and I mentioned them earlier. So there's the Complaints Task Force. The Complaints Task Force, first it had to design a complaint form. The complaint form is available on the state regent's website and the websites of each of the institutions of higher education. And anybody can file one. I've only been 4 filed, but anyone can file one. I've certainly heard about others thinking about filing complaints for a variety of reasons. They did not do so. That's one of the things that it does. The second, and this is the most time-consuming, is reviewing policies that might have an effect on free speech on college campuses. And this, obviously, it's extremely time consuming, reading a massive amount of paperwork for each institution, sifting through it. We've had some great assist from FIRE, for example, in helping us review them and them pointing out some things. We have a staff, and when I say we have a staff, it's a lawyer, one staff member basically with an assistant, and that lawyer helps us. Not all the members of the committee are lawyers. I think 4 out of the 9 are lawyers, including my colleague, Ms. Pitts, and I. And obviously we look at them, but that's one of the task force jobs. And the person that we have as the chair of that task force is a former dean of Oklahoma City University School of Law, former federal magistrate judge. So somebody who's quite knowledgeable about these issues, and she is extremely diligent about them. And then the third task force that we have is the one about educating administrators and those who deal with free speech types of issues or setting free speech policy. My colleague is the chair of that task force. Every 2 years, they are required to undergo some type of training. We've elected to put on our own training. We could use somebody else's training. We could call in another group. We've chosen to do it on our own, but we do it on our own. So in our initial one, we had a professor from the University of Oklahoma College of Law, who's a civil rights expert, lead the discussion. We had a panel then for a Q&A, and the panel, I chaired the panel, but I had 2 excellent lawyers who work full-time in higher education who did the bulk of the answering of the Q&A, and of course they did a marvelous job of that. The committee is advisory in nature. Nothing in our statute explicitly states that, but the legislation repeatedly indicates that the committee's jobs are to review, to recommend, and to advise. And policy 2.28, the policy that set what the committee would look like and adopted the Chicago principles and applied it to all of our institutions of higher education, explicitly states that the committee shall be advisory in nature. Because it is advisory, even when it gets a complaint, it does not adjudicate and it does not command, but it is a safety valve. It advises the regents, it advises the institutions, and of course it advises those who believe that their free speech rights have been violated. I'd like to mention, how this works in reality. How does it work in these difficult times, as we've been discussing? Just last month, back in November, we had an incident that occurred at the University of Oklahoma. It did not result in a free speech complaint. And these things can happen, they can happen anywhere, but a student was given an assignment. The assignment was to read an article about LGBTQ rights and give your reaction to it. Well, she wrote a reaction that said she disagreed completely with the article. She based her disagreement on the Bible. Those were her words. And she got a 0 on her paper out of 25 possible points. And, excuse me, the teaching assistant who gave her the 0 said it was for 2 reasons: for not using empirical evidence to say why she disagreed with the article, although the assignment didn't call for empirical evidence, it called for your reaction to the article, and that her article, her 650-word paper, was offensive. She appealed. She appealed not on free speech grounds, but on religious grounds, religious discrimination. the university ultimately decided that that her 0 would not count against her final grade. That in turn created another controversy about the teaching assistant and the teaching assistant's academic freedom. But in any event, I mention that because when we had our quarterly meeting, our committee has quarterly meetings, the issue came up at the meeting, and it came up because we were supposed to review, finalize our review of the university's speech policies. And the media saw that, so suddenly our committee, which generally doesn't garner a whole lot of media attention, garnered a lot of media attention. We postponed our review, our final review of those, of the university's free speech policies, but we did discuss the issue, and what I can tell you is that once we talked about it, and we talked about it with various media folks, it suddenly became less of a public controversy. I mean, the controversy still exists, and there's still articles being written about it, and who knows, other things may happen. But I think it illustrates how this committee is a safety valve. So even though it doesn't adjudicate, the fact that there's a place to go to make complaints, and to make complaints outside of the institution itself, but to a separate committee, I think makes a difference. And I think it makes a difference that it is set up by legislation. It's there until the law is repealed. The committee will continue to do its job, and I don't expect the law to be repealed anytime soon. You know, why has it worked in Oklahoma so well, and I would recommend it to other places as well? Well, there could be a lot of reasons. It may be because Oklahoma colleges and universities have had different experiences from campuses in other states. Perhaps demographics play a role. Perhaps Oklahoma's culture is a factor. But I don't think it's far-fetched to assert that the existence and the work of the Oklahoma Free Speech Committee, created by law, empowered by the Regent's adoption of the Chicago Principles, is statewide policy for all public institutions of higher education, has played a role. Freedom of expression is hard to do, as I think every one of these panels, every one of these speakers thus far has said. The rubber meets the road not as to views that are popular, but as to those that are not. I strongly believe universities should not indoctrinate. They must not indoctrinate, nor do they exist merely to pass on knowledge or to certify. Instead, they foster critical thinking and thereby pass on the key to lifelong learning and a better, more civil society. I think higher education must do better. It's not sufficient simply to espouse respect for free speech. We have to model it, and we should make a part of core curricula for our universities courses on civil discourse and showing our students how to do it. I attended I was in the other room for the first panel, and I heard something that unfortunately is very familiar to me, that our K through 12 schools have done a poor job, and that's not just their fault, it's our fault because we empower our K through 12 schools to do a poor job of teaching students how to have difficult discussions. I wish they knew how to do that when they got to college. They don't. We have to do it. I think that's the way that we, as those who are involved in higher education, can and meet the challenge of the times. That's what I hope we do. I hope you consider the Oklahoma version. Let me see what on my last slide was here. Oh, this is a meeting of our committee. You can see there, I sit as the chair. My colleague who couldn't be here is this lady right over there in the middle on that side. And that was our December meeting. I think we had one member who was unfortunately absent. And there you already heard me say my conclusion. So, thank you very much.
So our final speaker, right? Okay, but a paper written, co-authored by Lilach Litor of the Open University and Hadara of Netanya College. Confused.
So, good morning to you all. I'm Dr. Lilach Litor from the Open University of Israel, from the Department of Public Policy. And I studied together with Professor Hadara. It is about internal codes of conduct at Israeli universities and regulation. Now we know that freedom of expression is a universal right. It is enshrined in Article 92 of the Convent on Civil and Political Rights, and it is a very large freedom which enables us to explore and gather data and publish it, and it is one of the pillars of democracy. Nevertheless, in Article 19.3, there is a possibility of restrictions on freedom of expression when it is necessary to protect national security or public order. And so there is a tension between the academic interest in research and criticism and the legitimate claims to maintain public peace during the war. So these tensions rise, and there are questions such as are lecturers allowed to publicly criticize the government policy during the war, and where is the line drawn between legitimate expression and non-legitimate one. So in Israel during the war, academic institutions faced challenges of addressing expressions that were perceived as offensive, and some incidents highlighted a decline in the right to freedom of expression, including the suspension of lecturers and students due to statements. And this situation highlights the need for regulation and for guidelines that can balance freedom of expression with appropriate boundaries. So freedom of expression in academia is very important. It is a base for academic freedom and a base for free research and free teaching. Also, academia has a role in civic education and teaching students about critical thinking. So it is during war it can be an arena of tensions between rights and interests, between freedom of expression and other interests such as national political issues or governmental policy. We should also bear in mind that expression may cause infringement of the rights of other members of the academic community. So during war in Israel, we had a few incidents regarding professors and lecturers. For instance, the Shalom Kevorkian incident, where a lecturer in October 2023 published a statement about the states in the army during the war, and the university, it wasn't Hebrew University, and the Hebrew University decided to take a preventive step of suspension from teaching. And afterwards, she was arrested, and in a year, the chairman of the disciplinary committee announced that she resigned from teaching. Another incident was with Dr. Fane, who was one of the senior lecturers at the American College, and he spoke at the graduation ceremony and had a statement regarding the war. He said that there are innocent people being killed in the Gaza Strip. And following that, he was bound to resign from his position. Another case, for example, was in the K Academic College, where Dr. Valda Saada was fired for her statements regarding October 7th. Also, we had incidents regarding students that were also suspended from studies. Such incidents occurred, for instance, in the Haifa University. We had some rulings of the labor court also regarding public employees that were dismissed for their statements. So there is an emphasis on stricter restrictions on public employees by virtue of the civil service laws. When we think of the appropriate regulation regarding teachers and student statements, we can consider either state regulation, which is a compulsory regulation, or self-regulation by higher education institutions, which could be done through disciplinary regulations, codes of conduct, and internal codes of ethics. There are also different approaches, different regulatory approaches that can be taken. There is the classical liberal approach, which strives for maximum freedom of expression even during war, which is it receives negative aspects, only protection against governmental restrictions of expression. So it strives for minimum state regulation and for freedom of individuals to act, and places emphasis on free market mechanisms of expressions of opinions. And there is also another approach, which is the restrictive approach. The restrictive regulatory approach favors limiting freedom of expression in higher education in certain cases, and it emphasizes positive aspects of the right and considers government as one that has obligation to create a tolerant environment by limiting offensive expression. And this restrictive regulatory approach also is based on considering the universities as hybrid bodies which have public characteristics and therefore should be subject to public law norms and special obligations. I now will call Professor Hadara to talk to you about that.
Thank you, Lilach. Okay. How long do I have?
10 minutes.
10 minutes? Okay. The study examined
מי השמאל?
לא, בסדר, שומעים אותי טוב, כן?
כן, כן.
The study examined okay. The study examined disciplinary regulations and codes of ethics in higher education institutions for students and lecturers, examining the question of regulating freedom of expression. Academic institutions in Israel independently determine their own codes of conduct with no legal obligation to adopt a code of ethics, resulting in such codes existing only in some institutions. The disciplinary regulations at most institutions do not directly regulate freedom of expression issues, creating difficulties in protecting individuals and preventing offensive speech. The lack of a clear definition of freedom of expression undermines the scope of protection of the right and creates difficulties in recognizing the right itself. Sometimes reference can be found to academic freedom and freedom of expression in the Code of Ethics, but this regulation applies to all those associated with the institution by virtue of the Code of Ethics. Now, since I have 10 minutes, I will skip all the and I will go to the proposed model for regulating freedom of expression in higher education institutions. Later, when if I have the time, then I will show what happens in university, in Hebrew University, in the Technion, and the comparison to Australia, which is very interesting. But since the time is very short, so I will give the proposed model for regulating freedom of expression. First, we recommend to adopt a freedom of expression approach in the quasi-public academic space with free speech as the default. Faculty and lecturers' right to free expression and academic freedom should be given significant weight. Restrictions on expression create a chilling effect whereby academics avoid developing certain topics for fear of negative consequences, potentially paralyzing the system and preventing teaching and research. The starting point should be individual autonomy and freedom with restrictions only in extreme cases. Second, academic institutions should have autonomy to regulate their internal affairs and procedures with faculty and students. Self-regulation is preferable to coercive state regulation through legislation with sanctions. State regulation should encourage and validate self-regulation by providing incentive, relief, and recognition of internal procedures. Third, examine whether the problematic expression occurred outside or within the institutional space, and if within, whether it was part of a class or other academic activity. Expressions within the institutional public space should be held to higher standards and must meet proportionality requirements. Fourth, expressions made as part of academic research and published in academic forums should be immune from judicial scrutiny to protect academic freedom. As long as expressions are part of scientific research, no restrictions on free speech should be imposed. Fifth, examine the severity and content of the expression during wartime. During wartime, political expressions related to the fighting itself require greater scrutiny to ensure they don't violate citizens' fundamental rights or state security. Expressions constituting criminal offenses, including incitements to racism or violence, should be prohibited, and may serve as grounds for disciplinary proceedings against faculty or students. 6. Examine whether expressions relate to the academic institutions and are directed against institutional activities, harm the institution, specific student groups, individuals studying at the institution, faculty teaching at the institution, or other employees in appropriation. 7. Examine the nature of the role and position of the speaker. Faculty members holding additional administrative positions should be held to more stringent standards than regular faculty. Standards for faculty to refrain from offensive expressions should be stricter than those for students. Standards are more stringent when faculty expressions target the student community, especially when directed at students over whom they have authority or who are in their classes. 8. The new regulation should establish that internal disciplinary proceedings against students or faculty may, in some cases, serve as a defense against criminal charges or as mitigation in sentencing, considering the disciplinary sanction already imposed. In less severe cases, internal proceedings may obviate the need for criminal proceedings. 9. Similar to the Australian higher education, which if I have time, I will discuss about it, institutions should be required to publish their policies regarding freedom of expression and appropriate conduct of faculty and students concerning expressions. Hence, similar to Australian regulation, institutions must ensure a safe campus by removing all problematic expressions and hate speech from university property and all academic and digital platforms belonging to the university. Roy, do I have still some time? 2 minutes? Okay, let me look for the Australian. Here it is. Okay, so now, if we, since I wanted to compare to the Australian model, let me talk about it. The model adopted in Australia includes state regulation by an agency which constitutes a self-regulatory framework in higher education institutions. In 2094, regulations were established by the Australian Higher Education Authority that are intended to create a framework for internal regulation in higher education institutions and regulate issues of freedom of expression, including during times of war. This is interesting, you know, in 2094 they didn't know about the Bondi Beach, but this is what happened in 2095. The regulations were established in 2091 and set various standards for higher education on various issues, including issues of freedom of expression. The Australian Authority subsequently established specific regulatory guidelines in August 24 in response to offensive statements and made following the Middle East conflict. The explanatory notes to the regulation regarding freedom of expression during wartime state that it is being established due to statements, protests and demonstrations across campuses following the war in the Middle East and with the aim of requiring higher education institutions to regulate the issue and meet the standards set in the regulation in 2021. The Australian Higher Education Authority has established obligations on institutions that provide higher education to ensure freedom of expression and academic freedom of students and lecturers, along with ensuring the rights of those whose problematic statements may harm. It has been determined that it is essential that the institutions themselves regulate this issue. Okay? Okay. Thank you.
So I'm going to use the chair's prerogative to address a question that is thought about to Joe, which is how would you recommend universities going ahead deal with these issues without falling into the unconstitutional practices described?
Okay, well, I was going to suggest that maybe the panel should sit there for Q&A.
Yeah, actually I thought of doing that.
Why don't we, is that
Why
what
don't
you
you have
that
that? Meanwhile, have Andy
for everyone, I think that might be
Thanks.
a little, I'll slide all the way down.
So I think it's a mistake to think that the tensions between free speech and addressing anti-Semitism are unresolvable. And I think there are a lot of steps that institutions can take, and I'm talking about through the American legal framework, but I don't see any reason why you couldn't do this anywhere else in the world. You know, when thinking about the different contexts of anti-Semitism, I think you need to look and see if curriculum is biased against Israel. Institutions should take steps not to silence, pro-Palestinian, professors, but should take efforts to make sure that the alternative perspectives are also available and in the curriculum as well. And to look and make sure that teaching, not just on this issue, but on any issue, is scholarly. You can have opinions, you can draw different conclusions from different facts, but no one's entitled to make up facts. So I think that going through a process of committing to the norms of what academia is supposed to be is an important step. Another thing I would say is a significant source of the problem, at least in the United States, is the administrative student life apparatus at college campuses has for 20 years been framing things in an all or nothing purity model of either you're for or against social justice, and then hiring people as true believers, not just in this context of anti-Semitism of Israel, but also in terms of other issues. And I think getting away from that and making sure that campus administrators are instead focusing on multicultural collaboration, how to resolve things, how to discuss and debate areas of difference. Pro-Palestinian professors are teaching pro-Palestinian stuff. They're being really misleading about what they're saying about Israel. They want to shut that down, and there's a massive effort in the United States, and I'm pushing against that effort. And and what I'm trying to say here is that it's not that there's never any breach of a professional responsibility as a professor, but that breach, the question of whether or not you're in breach as a professor, can't be what view you're presenting. Has to really be about not the conclusions that you're drawing, but are you actually going through an academic process that is, not belittling, students for having, different views, even if you're going to disagree, strongly. It's not about omitting facts, etc. So I agree with you that it has some involvement there, but you're talking about either full involvement, we disagree, so we're shutting it down, or no involvement, and I'm saying you really have to be there on what you're
Just to understand one thought on that. So this professor teaches a course on the war in Russia and takes a very one-sided. In the syllabus, you look at the syllabus, you realize that's one-sided. You recommend that the university do what?
So I don't think it's a problem for a faculty member to have their perspective, and like you have a class saying why Russia is right, and I expect that professor to talk about why Russia is right. But if you're going to have in the academic department in the university saying, okay, but we're only going to hire people who are going to express the pro-Russia view, well, you might have a problem there in terms of the legitimacy of your overall.
You don't mean the
program.
syllabus of the specific course.
No,
Course offerings.
Right,
of the
broad,
department.
exactly.
You're talking about hiring decisions. So that, you have. Okay, go ahead.
We can go more.
And I have a question for Joe and a suggestion for Hadara.
Okay.
First, start with the suggestion. There's a specific paper. I don't think Nina is here.
In Levine?
Yes. She's gonna talk about the way the Australian code of the.
No, someone else. Okay, Australia. She will. Right.
No, she's here.
She's here.
She's in the other
I was about to say she already spoke, but I was being anti-Australian and discriminating. and
She's in the play.
conflating her with another
Anyway,
Australian.
she's presenting a paper after lunch about how the Australian Code of Free Speech did not manage to administer or to anti-Israel and anti-Semitic conduct. So that's interesting. We have free speech, but again, it didn't protect anti-Semitic. My question to Joe was specifically about hate speech. Because you emphasize that hate speech is not unprotected under the First Amendment. But does that necessarily mean that universities cannot regulate hate speech?
Yes.
Yes,
They cannot.
They cannot?
And what I will say is
Private universities
no,
cannot.
hold on. Almost all universities cannot. And the almost is this. None of the public can, because institutions of higher education as government entities must abide by the First Amendment, and the First Amendment says that to protect speech. Okay? And then private institutions that promise free speech and academic freedom, then that case law gets imported in, of which there are probably somewhere between 8 to 12 universities in the entire country that say, private institutions that say, we're religiously affiliated, we're BYU, we're trying to create this, or Hillsdale, or whomever.
I understand.
So-
So in Israel, for example, if we were under your
First Amendment.
Yes.
regulation, so if we have Jewish students running around saying death to Arabs, we can't do anything?
So,
It's not imminent.
no.
It's just hate speech.
Right. That's right, because a lot of the things that you have to do are contest bad arguments. The idea that censorship will somehow stop people from holding those views, or will make it less persuasive, has never, and when I say never, I mean, I'm not an absolutist in a lot of ways, I'm not a person who will say, but I can't think of a single example in world history where censorship has stopped the spread of an idea.
But that's not the
so-
only concern.
It's not the only concern, but what you do have is a long history of instead pushing ideas into echo chambers where they grow. So that's the philosophy behind.
I'm just saying, it just seems unacceptable. That the Jews, can students at Yale run around and say, have signs, death to Jews, death to Jews?
Well,
It's not imminent, then you can't regulate.
But imminent is not the only exception. You also have harassment standards when you're actually going after people and
We're
targeting.
not going after.
But
We're just
that depends on-
expressing, that view.
That depends on the severity and the pervasiveness of determines whether or not it would be in context. So the
It's
overall
still general, it's not targeting
the
any
overall general
individual.
statement is going to be protected.
Joe,
But there
Joe,
are ways in which it could be
You
unprotected.
sound like the university presidents of the country. Okay, it all depends. Just
No.
Answer the question.
I am answering the question. It is protected. I'm going to say this unequivocally. And here's the problem with the university presidents. The university president said the right legal thing, but they also violated those same rules that they were defending to Congress every day for other groups. They had no credibility when they said these were the lines because they weren't doing it. I, on the other hand, have a 21-year history of being consistent on it. And the law is the law at the end of the day. And the reason why it says that is not the view that there aren't real considerations on the other side. It's the view that it's more harmful to engage in censorship than helpful, for a long list of reasons that we can talk about.
But one very
I'm
related
a rights
clarification.
lawyer, I know all the
Yeah.
considerations.
I understand.
I'm saying that it just seems that the university.
But just one very narrow clarification, if I'm a private university, going forward, I can change my policy and say, for all future students, know that we will not tolerate hate speech. And we will put that in our code. Yes, future looking, I can do that.
I think that that's probably right with one caveat, which is, the courts are going to be divided in different jurisdictions about whether or not they will allow that. And the way in which they're going to parse is the question of how specific is your promise of free speech versus your exception, and can that promise of free speech live within the exception, or has the exception been so broad that you're driving a
But
truck?
I'm gonna hire you to word it, so it's gonna be phrased very specifically.
Well, but you're going to have different judges deciding that.
I thought the main argument against this type of speech is that it will cause action in the end. That if we will say that's to the Jews, then it will end up killing Jews. And so that's an argument to block this kind of speech.
That's the incitement
But
exception.
it's not
That's
incitement,
incitement.
it's,
Well, let's take another question, because I think we're,
Yeah. We can talk more about it.
Thank you. Hi, I'm Alvin from Hebrew University. For just a small statement, we're going to address some of these contested ideas in our talk after lunch with our idea of freedom of expression as a quasi-social right. But what I want to actually ask here is following the Hadara and Lilach's point, which came up from Andy and I think also from Joe, on legislation or some kind of regulation, like state regulation, right? So there was Cohn, and here we want Israel, and here we have. It seems as if in Israel and in the U.S. Currently, there's actually a real, contestant of ideas between the government and higher education institutions. So higher education institutions are those that are safeguarding freedom of expression, safeguarding equality, safeguarding a safe place for students, while governments, also the U.S. government and the Israeli government, are trying to shut down voices and to apply sanctions on what's happening in the university. So I'm wondering really whether under this atmosphere going through a process of regulation is beneficial in any way. And why not lean on what is happening, at least in Israel, and I know also in the US, on internal codes of ethics and internal regulation policies on freedom of expression and the dynamic between freedom of expression, equality, dignity, and other interests, which I think are, and we have learned of some in the previous panel, and we're going to learn of more in the next discussions, are quite effective in a sense, right? So I'm wondering whether legislation or state intervention is beneficial under our current atmosphere.
So let me at least partially respond to that. Here again, what we've done in Oklahoma is the legislation is saying we recognize the First Amendment, government has no right to regulate people's speech with a couple of exceptions that Joe mentioned. So we're starting from that. We've then adopted, and I didn't really go into what the Chicago principles say, but the Chicago principles are all about freedom of expression. We understand there are perspectives that are difficult, they are challenging, they may be extremely unpopular, they're not something that most, or maybe even any members of the university community agree with, and they may detest them, but they're still allowed. That doesn't mean we have to welcome them in the sense of, gee, I'll take all opinions and I think they're all this. None of us thinks that. That's simply unrealistic, and I can't imagine somebody thinking that way. But with that said, our job as this free speech committee is to make sure that our government officials, and do remember that public university employees are government officials. They are employees of the government, every single one of them. That they cannot tell their students, they can't do things to abridge the professor's freedom of speech, the students' freedom of speech, the people that come onto the campus's freedom of speech. Now, they might be
You
able
don't consider them as having freedom of speech? The professors or the president, the administrators?
Well, certainly they do have freedom of speech now. Employees are put into a different category than the public to some extent, to the extent that they're not acting as members of the public. Professors, their freedom of speech, in some sense, is greater than other people's freedom of speech to the extent that, and our Supreme Court hasn't fully elucidated on this, but to the extent that they have academic freedom. Academic freedom is something that we treasure in great regard. But what our committee does isn't, we don't regulate speech. What we do regulate is, to the extent that we regulate, is the regulation of speech. We say you can't do it. And we're there to enforce that help enforce that right, and certainly to guide those that feel like their free speech rights have been restricted somehow on what they can do about it.
If I could just be real fast, and I don't want to dominate, I would, and we can follow up afterwards, I think it's a mistake to view either the government or on campus as being always right or always wrong on it. There's certainly been a lot of censorship that has come from the campuses, in particular with campus administrators who will, try to regulate what they think is hateful speech on any number of issues, and often it's targeted against people for the opposite views that you would think. Pro-Israel speech being hateful towards Palestinians, or what have you. I mean, it's the subjectivity of it that becomes the issue. So we have seen a trend, particularly from those who think that academia is a monoculture, of politics, to see the censorship coming from one direction when it's coming from campus, and coming from the other direction when it's coming from governments in states that are from that side, or now that the federal government is held by Republicans as well. So my view is that regulations that set forth the principles and the rules consistently protecting speech are smart regulations, and regulations that would infringe on people's speech, whether at the campus level or at the government level, should be contested.
I will give John, you want to answer? The Hebrew University's disciplinary regulations do not contain an explicit provision regarding freedom of expression. Still, there is a general provision regarding a disciplinary offense that concerns behavior that is inappropriate for a student at the university. It can be interpreted as subject to the explicit provision on freedom of expression in the public activity regulations. Now, let me give you also the comparison to the Technion.
But we do have actually.
Yes,
Ethical code for
yes,
freedom of
yes,
expression.
you do have. In Technion disciplinary regulations, the actions defined as a disciplinary offense include discriminating students, faculty members, or candidates for this on the basis of the political opinion, abusing their position for political propaganda, and systematically preaching a political opinion, including presenting one's political position in a manner that misleads one into thinking that it is in the Technion position, which means that you have the arrangement with that.
What is important is that the regulation or legislation will be a framework for internal regulation. Because the internal regulation sometimes is not consistent and doesn't address the necessary things. So if the state regulation can give it effect. For example, internal proceedings can be protection on criminal proceedings afterwards. So, and therefore, it can give effect to the internal content.
Okay, I have more questions, which I'm going to ask over lunch, because it's a time of day we can't go on talking without eating. Thank you all.